Hi, my name is Shea Backus. I'm an attorney with the law firm of Backus, Carranza, and Burden. And one of my areas of practice is construction law, and I handle construction law in two different matters. I either represent contractors, subcontractors, design professionals in getting paid, or even representing owners dealing with contractors that are pursuing claims against them for payment, in which they may have counterclaims for delay or other issues that may have arisen during construction of a project. I also practice construction defect work in which Nevada is governed under Chapter 40 for construction deficiencies, whereby I more than likely represent the contractor, subcontractor, design professionals, supplier, or even manufacturers in defending claims against construction deficiencies. Today I'm going to try to give an overview of these areas of law which are pretty statutory intensive. First, we're going to discuss Chapter 108. This is Nevada's mechanics lien law. I'd also like to refer you to Chapter 624, which is the statutory provisions that govern contractors. Specifically, under Nevada, we have a prompt pay statute under Chapter 624 that I'd reference you to, in addition to Chapter 108 for Nevada's mechanics lien law. Getting started, a lien claimant who benefits from Chapter 108 is any person who provides work, services, or materials to a property that exceed $500. This person could be anywhere from a contractor, subcontractor, design professional, all the way down to geotechnical engineers if they're just doing soil sampling at the project. It's anyone that's doing improvements to a property. A lien claimant has a lien against the property when work is commenced. The value of their lien is determined upon whether or not there's an agreement for the price of the work being performed, or if there's no agreement, then Nevada has defined what that value of a lien would be by the fair market value of the work furnished or to be furnished. I wanted to highlight with respect to the lien where there's an agreement, the lien value is actually the amount under the contract for any work that has already been furnished and that will be furnished. One key thing is if a client comes to you, and this has happened to me, if a person who's performed services for a resident, that the person is not a licensed contractor with the State Board of Nevada, that person does not get the benefits of a lien claimant. Because they are an unlicensed contractor performing such services. Like if you have a buddy who you say, come on over and paint my house, with that situation you don't pay them, they don't get the benefit of a lien against the property. There's also penalties that I would refer you to under Chapter 624, Section 700, that provides actually criminal penalties for an unlicensed contractor who provides work improvements to a property and is unlicensed. Also, if you enter a contract with such unlicensed contractor, that contract is void ab initio. Before recording a lien on a property, there's certain things that you need to talk to your client about and consider. Did that contractor or person who's improving the property actually have a contract with the owner? If they didn't have a contract with the owner, then there are pre-lien requirements under 108 that requires that when the contractor or design professional, and I'm going to use in generalities through this presentation, contractor, to cover a contractor, a subcontractor, a sub-subcontractor, a design professional, or a materialsman. A materialsman is a person who provides materials or supplies materials to a project. For easy, just referring collectively to these individuals as the lien claimant. So with respect to a lien claimant who doesn't contract with the owner, and also to be out of caution, it's always good to pre-lien the project. And what this essentially does is give notice to the owner that potentially a lien could exist on their project or property for work being performed. In this situation, there's requirements that would have to happen. You have to give notice to the owner by certified mail. And the provisions that you would take a look at, there's specific forms. The nice thing with Chapter 108 is each of these notices that are going to be sent to an owner or contractor, depending on what the notice is under Chapter 108. The forms are written out right there. It is set forth exactly the language that has to be used. And for a pre-lien notice, you would refer to chapter under Nevada, you would look to NRS 108.245 subsection 1 for the form of a pre-lien notice. This can either be delivered in person or by certified mail to the owner. This notice, what's important, because usually what ends up happening is a client doesn't come to you until the end of the project. And the problem being with that is if your client, who's the lien claimant, doesn't have a direct contract with the owner, a pre-lien notice is only good for work performed within 30 days prior to that notice being given. Once that pre-lien notice is given, it's good all the way through the end of the project. It's imperative if you do have construction clients, they are aware of that. Even if they do contract with the owner, it's a good habit to get into to pre-lien any notice, pre-lien any project that a contractor is going to work on at the start of the project to cover the entire time frame of the project. That just makes sure the owner is aware they're there. Nevada does have lots of case law that I would also refer you to with respect to who the owner is, how notice is given, and that is case law, and it broadens that just to make sure that, because the key is that the statute is followed, but there is case law that I would like to refer your attention to. Under Nevada, we used to have statutory construction that allowed a contractor to waive their lien rights. That is not the case now. It's against public policy. The only time that a lien could be waived is there's two provisions for conditional and unconditional lien waivers, and this is basically premised upon payment during progress payments and at the conclusion of a project for final payment. And that would be under NRS 108, section 2457 for those limited waivers. With respect to the lien, now the lien kind of exists from the work that's being performed. A contractor or a lien claimant that is not paid has to perfect their lien. And there's specific statutory timelines that have to be followed. One thing I would recommend, and I wish I recommended this at the beginning, is one thing I've learned through the practice of law is you always need to double check what the statutes say, what rules say, just because rules change, or you may read something that may change down the road or may actually have language that you weren't expecting. And it's imperative, especially with perfection of liens, that the statute is followed. And under NRS 108.226, provides those specific timelines that have to take place for perfecting a lien. Specifically, a lien must be recorded within 40 days after the completion of the project if a notice of completion is provided. Notice of completion has also statutory mandates under NRS 108.228 that must be presented in the notice of completion, which will trigger a 40-day deadline, and that is basically from the time that you would a lien claimant would receive service of that notice of completion. Other than that, if no notice of completion is recorded or served on the project, then the timeline is 90 days after the date on which the latest of the following events occur. 1, occupation or use by the owner, and that also must be accompanied by the work stopping. So if an owner occupies a residence but work's still going on, that doesn't satisfy that one prong. The other prong is acceptance by the owner and of the work performed, and once again, all work is completed at that point. And lastly would be the completion of work of improvements for 30 consecutive days, and once again, provided a notice of completion is timely recorded. So basically, it's either going to be a 40-day period or a 90-day period that will trigger when a notice of the lien must be recorded against the property in order to perfect the lien. Nevada, once again, has specific requirements for the notice of lien document. Once again, the wonderful thing is there is a form that's set forth in the statute under NRS 108.226, subsection 5, and each of those basically contain the name of the owner, the name of the person by whom the lien claimant was employed. So if it was a subcontractor, you would list out each of the persons that had employed the lien claimant, the terms of the payment, for example. progress payments at 30%, 60% clean, 30%, 60% completion of project payment would be paid. The terms of the payment would be set forth. Also, a description of the property has to be set forth on the notice of lien, as well as it has to be verified by oath. Just a practical tip that I would suggest with any of the notices that are being recorded against a property, and the notice of lien is one of those items, is that you comply with all of the recorder's requirements, because a lot of these timelines are being triggered and they're short. And so if you show up at the recorder's office on the last day and the form is incorrect, the recorder sometimes may wipe their hands and say, take a hike. But I think it's imperative to check those out. One great tip that I have is this margins. Margins have to be 1 inch. I would recommend setting your margins for each of these recording documents to 1.25, and also make sure you use black ink. At times you can sit there and repair the document, but maybe you won't be there and a runner will be there, so it's imperative to make sure that your documents that are going to be recorded against the property are correctly filled out in accordance with NRS 247.110. Another side note is if the notice of lien that's going to be recorded is for a resident or a multi-family residential project, you have a duty to do a 15-day notice of intent. Once again, this is a form that's set forth under NRS 108, and this gives the owner and potentially also the contractor notice to, hey, get us paid. If not within the 15 days expire, we will record a notice of lien. So in those limited circumstances, you need to make sure you do a 15 notice of intent to lien. With both of these documents, there are specific service requirements with respect to a notice of lien, not the notice of intent to lien, but the notice of lien. You have 30 days after it is recorded to serve it upon the owner of the property. The methods for service include personal service, mailing it by certified mail return receipt requested. Also, if for some reason you don't have the address of the owner, there are other specifics where you can post the lien at the place of property. It just has to be in a conspicuous place, and also deliver a copy of the lien to a person residing at the property. And that lien also has to be mailed. I would just suggest that you take a look at NRS 108.227 for those alternative methods if mailing it via certified mail return receipt doesn't work out. Also, one thing is you want to send a copy of that lien to the prime contractor. The failure to serve the prime contractor isn't like the lien goes away, the owner can use that as a defense. Instead, there's just the failure to serve a copy of any lien recorded to the prime contractor if you're not representing the prime contractor is just grounds for disciplinary proceedings under 624 to the contractor. Likewise, if there's a construction control account, also take a look at Chapter 108, as there is a lien in the value of the construction control account for the work being performed that may not be paid for. If the owner has already paid the prime contractor and you represent the subcontractor for the work being performed, essentially the prime contractor then owes a duty to defend the owner for any of the claims but typically in this world we've run into prime contractors that are out of business, but Nevada does have that duty to defend of the owner by the prime contractor under NRS 108. The other thing is if a lien claimant does record, the lien claimant is a subcontractor or a party that contracts with the prime contractor, the owner can also withhold monies due under that lien from the prime contractor and can elect to hold those monies. They don't have to pay the prime contractor, but to deal and address the lien claim. If the lien is satisfied at any times, basically the lien claimant has a duty to release the lien within a reasonable time. Basically the statute requires it that be a reasonable time that is immediately practicable, but basically it should be within 10 days. And once again, you would record a discharge or release of the notice of lien, and this legislature has been so nice to provide a form under NRS 108.2437 subsection 1. Failure to do this can result in the lien claimant being responsible for actual damages or $100, whichever is greater, for failure to timely record a release of lien. The duration of a lien. Once the notice of lien is filed, it needs to follow through with a lawsuit being filed timely, and that's within 6 months of the recording of the notice of lien. There is a statutory method that allows you to extend the time to file a lawsuit. However, that statutory time period has to comply with an agreement with both the owner and the lien claimant. Must be in writing, must be recorded. There's a lot of provisions setting forth, and I would refer you to NRS 108.233 for those mandates. One thing I would caution you representing a lien claimant is you need to be well aware of NRS 108.2275. This deals with the recording of frivolous liens. A owner can immediately petition the court to address the frivolous lien. This comes with penalties to the prevailing party of attorney's fees and reasonable cost if the lien is frivolous. Likewise, if the lien claimant prevails on if there is a motion filed during litigation, or if a petition is filed by the owner, then likewise the lien claimant could be entitled to fees and cost. The court has the right to hold a hearing in a timely and quickly fashion to hear the sides and make a ruling, and can either order that the lien is frivolous and must be removed, or could order that the lien may need to be decreased in value. A lien can always be amended. A notice of lien could always be amended. You must comply with NRS 108.229. With respect to a lawsuit to enforce the lien, the venue is always going to be the county where the lien has recorded. There are specific complaint requirements that must be pled. One of the items that also must be pled is that the lien claimant is a licensed contractor or design professional within the state of Nevada to be entitled to that relief under the lien. When the complaint is filed, there are other procedures that must need to be complied with. For example, a notice of pendency of action must be filed and also recorded against the property to place others that have an interest in the property on notice. Likewise, a notice of foreclosure must be published in a newspaper at least one time per week for 3 consecutive weeks. This is key. This notice of foreclosure also has to be served upon any and all other lien claimants who have an interest, that have recorded a notice of lien against the property, so that they're put on notice of any litigation. This allows other lien claimants to essentially interplead into the action, and how they do it is they file with the court a statement of facts, basically setting out their interest in the property as a lien claimant. And the originating lien claimant or other parties that are interested in the suit can always file an answer to that statement of facts. One thing that I've run into is it's always important with enforcement of liens through litigation to essentially foreclose upon the property to get paid, is to also bring in the lender. And one issue, Nevada is very clear on this. Under NRS 108.225, we have a statutory priority of liens. Essentially, the lien claimant takes priority upon once it starts performing work over. That's where their time starts. If there's a mortgage that's recorded afterwards or inadvertently isn't recorded against the property, the lien claimant actually has priority. I had the privilege a while ago, about maybe 2 to 3 years ago, in Nevada, our district courts were dealing with this priority issue, as there is a common law doctrine called the equitable subrogation law, and this basically in other states allows a mortgage lender or subsequent lender to jump over other parties that have interest in the property by taking the place of the first, if that lender is paying off the first mortgage. Our court has answered a certified question from a bankruptcy proceeding in Ray Fountain Blue that basically says the equitable subrogation doctrine does not apply to Nevada's lien law. Nevada's lien law is specific, the statute is clear as to its meaning, and the equitable subrogation doctrine does not apply. And that is in Re Fountainblue Las Vegas Holdings 209 P3D 1199, and that opinion came out October 25th, 2012. Before that opinion came out, our district courts were ruling in various ways. We just didn't make it to the appeal because the case is settling, but the bankruptcy court was able to get that question certified, and now it's answered for those that are enforcing liens through litigation to foreclose on a property. Also, with multiple suits that may happen because multiple liens filed upon a property, those suits can all be consolidated. With respect to suits being brought under Chapter 108 under Nevada's mechanics lien law, a party can always seek a preferential trial. That's under NRS 108.239. The court can also dispose of lien claims in a summarily fashion. They can order a special master or someone else to hear and adjudicate lien claims. That provision is under NRS 108.239, subsection 9. In Nevada, we have provisions for what the prevailing party to a lien claim may be entitled to. They're not only entitled to their lienable amount, but a prevailing lien claimant is defined by statute under NRS 108.22156, which provides prevailing lien claimant means a lien claimant to whom an amount is found due by a trier of fact on a notice of lien or claim against a surety bond. Once the court determines who the prevailing party is, basically if the lien claimant prevails, then basically the court has the ability to award the following additional damages: the lienable amount found due to the lien claimant by the court, the cost of preparing and recording the notice of lien. This includes, without limitation, attorney's fees, recording costs, those items, as well as interest. When looking at interest, you always first look to the contract between the parties. If no contract exists, then basically it's going to be, the interest rate is prime plus 4%, and prime's determined the January or July preceding the judgment, and then would adjust thereafter each January and July. Also, the lien claimant could be entitled to, the prevailing party, lien claimant, could be entitled to cost of the proceedings, including without limitation reasonable attorney's fees, the cost for representation of the lien claimant in the proceeding, and any other amounts that the court finds to be justly due to the lien claimant. If there's more than one lien claimant, Nevada has a priority statute of how the lien claimants are to be paid. Specifically, NRS 108.236 subsection 1 sets the priority as follows. The laborers take the highest level of priority, then the material suppliers and lessors of equipment, then the lien claimants who have performed their work whole or in part under contract with the prime contractor or any subcontractor. Then last in priority would be all other lien claimants. This is important if a property is being sold and there's not adequate resources from the sale of the property to pay all the lien claimants. This is an order that they would be paid in the preference of each of those different categories of individuals who are lien claimants. If the lien is not upheld after a hearing in the matter, then essentially the court does have the ability to award the owner of the property its reasonable attorney's fees and cost for defending the action. If a property is sold and there's a windfall of proceeds from the sale of the property that overly compensate each of the lien claimants who have filed suit, the balance of the monies due after payment of all of the lien claims and also the cost associated with selling the property would then go back to the owner. The owner would be entitled to those proceeds. Once, more likely in commercial construction, you'll deal with an owner who is financially sound, and there may be issues with ongoing construction where they don't want liens against their property, and they have the right to secure a surety bond that they can record against the property that usually is 1.5 times the amount of the lien. And basically, by recording that surety bond, it removes the lien off the property. And so when the lien claimant does end up filing its action, it's usually against the principal of the surety, which is the owner, and also the surety as well, so that they can be compensated for the work that they've performed, the monies due and owing under that for that project.